Well, welcome. Thank you for joining us here today, either in person or by live stream, to the Federal Society program, Recent Developments in Corporate Mergers. We're very pleased to welcome you all here today. I'm Dean Reuter, Vice President, General Counsel, and Director of Practice Groups at the Federalist Society. We've got two experts with us today. Josh Wright's not going to be able to join the panel this afternoon, unfortunately, but we are going to carry on without him. We're going to hear opening remarks from each of our two panelists, some 5 to 10 minutes per person. Then I might ask a question or two, but then as always, we'll be looking to the audience for questions. We've got a couple microphones in the audience, so please use those when we get to that portion of the program so that people on the live stream and the recording can hear the questions as well as the answers. Now, despite the FCC's rollout today, we're going to try to avoid net neutrality as a topic, except to the extent it might inform discussion about mergers in the media and telecom space. Then it would be fair game. And we're going to focus quite a bit today on the proposed AT&T merger, but really use that as a springboard to discuss other mergers in this space as well, the telecom and tech space as well, like Sinclair, Disney, and so forth. We're going to get background information and an opening statement first from Jeffrey Manny. He's the founder and executive director of the International Center for Law and Economics, a nonprofit, nonpartisan research center based in Portland, Oregon, so he's come a long way to be with us. Thank you, Jeff. After graduating with his JD from the University of Chicago Law School, he practiced antitrust law and appellate litigation in private practice, clerked on the Eighth Circuit for Judge Morris Arnold, and worked as a professor at Lewis and Clark Law School. He's the author of the definitively titled article, "There is no antitrust case against AT&T."
I stand by the title, although I did not write it.
Okay. That's in the Wall Street Journal last month. There he criticized the economic assumptions at the foundation of the Department of Justice lawsuit challenging the AT&T Time Warner merger. In the article, he argued that it would not make economic sense for AT&T after the merger to withhold Time Warner content from competing distributors. That seems to be the overriding concern of the Department of Justice. Then we're going to hear from Mr. Harold Feld. He's the Senior Vice President at Public Knowledge. Welcome. That's a nonprofit public interest group dedicated to promoting freedom of expression and open internet and access to affordable communication tools and creative works. After graduating from Boston University Law School, he clerked on the DC Circuit Court of Appeals, worked on accountability issues at the Department of Energy, and was an associate in private practice. He's the author of the also definitively titled competing article, "The DOJ's Case Against AT&T is Stronger Than You Think," again. He didn't mention you in the title, though, Jeff. No. That's published on the blog Wet Machine. And he, in that article, makes the case that the AT&T Time Warner merger presents a significant risk of harm because of vertical integration issues. And I think we'll hear more about the distinctions between vertical and horizontal mergers as we go forward. He also argues that AT&T, after the merger, can control a substantial amount of must-have programming, allowing it to exercise undue influence over other programmers. He makes the case as well in favor of divestiture and other structural remedies rather than behavioral remedies of the type that the Department of Justice has recently pursued in other mergers. Now, all this happens while Makan Delrahim, the new head of DOJ antitrust, has a reputation himself, I think, for being opposed to behavioral remedies. And the DOJ doesn't appear to be considering them in the AT&T case, opting instead, at least as far as we know from all the reporting going on, to seek structural remedies like divestitures. And that might or might not be a point of disagreement between DOJ and AT&T, or even between our panelists, but we'll see going forward. So again, both of you, thank you very much for being here. Jeff Manny.
Thanks, Dean. Thanks to the Federalist Society for having us, and everyone for attending and turning your attention to this and not to the FCC. As I was saying before, both Harold and I are much happier to be here than at the FCC. I thought that I would basically since Josh Wright and I were going to say the same things anyway, I just thought I would take his time for myself, if that's okay. But what I will do is, in my opening remarks, try to give a little bit of the background of the relevant markets, the relevant industries in which the AT&T Time Warner merger is taking place, in the hopes that will help inform the discussion, and I think a lot of that will be relevant if we talk about other mergers and other deals that are going on. A lot of that will be relevant as well, so it won't be time wasted. Plus, it's really interesting stuff. So I'll do that, and I will also, somewhat interspersed with that, but a little bit more toward the end, lay out my theory of why I don't see antitrust problems with this merger. And then again, to the extent we talk about other cases later, I'll defend those mergers as well, probably. It wouldn't be any fun if I didn't, right? This is a merger, the AT&T Time Warner merger, between a telecom company and cable provider. So AT&T, of course, both has DirecTV and Uverse, through which it offers internet and cable services, and of course it's a telecom company, a mobile telecom company, with a content company. Time Warner has no relationship to Time Warner Cable anymore. It's purely a content company that offers cable channels, film and TV production studios, and the like. So it's an input provider, the content company, merging with a distributor, a sort of classic vertical merger situation. Not that I'll say right at the outset that it's all that simple, because Time Warner itself is already vertically integrated, even within its own purview. It creates content, the Harry Potter movies, for example, and distributes content through various channels like TBS and HBO, let's say. So things are always more complicated than they seem. But I'll come back to that point a couple of times, because it's important to sort of look at how vertically integrated companies in this space are currently operating to get some insights, I think, into how a post-merger vertically integrated company would operate. Most of this background is in some ways going to be familiar, unless you're one of the few people who still reads books instead of watching TV. So, but again, it's kind of fun. So home distribution of video content takes a number of forms today. I think the most familiar is cable and satellite providers like Comcast, Dish, and DirecTV. They offer packages of cable channels, sort of pre-bundled shows that are distributed over channels, and then bundles of channels, and there's massive amounts of content being offered, different size packages, but all of them fairly substantial. They also offer video on demand, and increasingly app-based content. For example, you can now watch Netflix through Comcast's Xfinity devices. Other channels are increasingly important. We all know about Netflix and Amazon Video. There's also Hulu, other smaller digital distributors, some of them very channel specific. So HBO has its own, excuse me, its own app called HBO Now that distributes only HBO content. You can watch it on your browser on your computer or through an app on your mobile device. CBS and several other networks have their own streaming channels, again, accessed the same way. But there's more, of course. Important to consider is that entities like Apple and Google, in this case through iTunes and Google Play, offer individual episodes of TV shows and movies, of course, or entire seasons of shows, both on mobile devices and via devices connected to your TV, which make it look an awful lot like you're watching cable or anyone else who's showing their content to your TV. So the industry, even as I've just described it, the industry has changed quite a bit from the days where you might have thought that the only way to get video content sent directly digitally to your home was through a cable or satellite provider. But it's changing even more. There's an increasing number of cable and satellite providers and other entities that are offering various innovative options to purchase less than full packages, the so-called skinny bundles of channels or even a la carte programming. Okay, that's the sort of lay of the land in terms of the distribution of video content to your home. I'm sure there's some things I left out, and frankly, I'm sure there's some things that have emerged literally since I started talking, the rate at which this stuff is changing. We may talk a little bit about the fact, for example, that just yesterday it was announced that T-Mobile is buying Layer 3, which is a TV sorry.
Yeah, it's very hard to know what to call
It's
it.
hard to know what to call it, but essentially will enable T-Mobile to offer cable-like programming over its mobile networks. On the content side, Time Warner owns Warner Brothers, which produces movies and TV shows, smaller production companies like New Line Cinemas. It also owns content produced by even smaller entities, both ongoing and defunct. So it owns all or some of Hanna-Barbera content. It also owns some or all of Castle Rock's content. It owns, as I said before, channels of distribution itself, including HBO, TBS, Adult Swim, Turner Sports, CNN, big brands like DC Comics. Sounds like a lot, but all of this is actually a drop in the bucket. Turner channels comprise something under 10% of viewership. I'm not positive exactly how that's measured. In fact, I think there's a lot of uncertainty about a lot of these numbers, but I think that's probably not far off of TV viewership today. Warner Brothers has some huge films, the Harry Potter franchise, for example, but still only something like 15% of the US market. And finally, and this is often, I think, missed and really important in discussions of this industry, content doesn't emerge from within these distribution entities. Sometimes it does, but far from always. And there are literally hundreds of film and TV development and production companies out there. And even they don't always originate their projects. Many come from independent writers and producers on the open market in the first place. But just take Warner TV. It has current or very recent shows, I just looked this up, that it created that are actually owned and distributed by, this is not a complete list, Fox, ABC, CBS, NBC, Netflix, Hulu, HBO. Right, this is a Turner company. It is responsible for the production of this content, sort of initially. But HBO, for example, which is the only one of those companies that's owned by Turner, subsequently purchases the project, and it becomes an HBO project, even though it may very well have originated somewhere else. Or take a smaller, but in some ways no less important production company like Bad Robot. It's affiliated with Paramount Studios, but it's run virtually independently by J.J. Abrams. It created Westworld. Westworld is now owned by HBO and one of its most popular shows, but it didn't originate with HBO. It originated with J.J. Abrams and Bad Robot. The list goes on. The point is, sources of content abound, and few of them are exclusive to any big studios or networks unless and until they're bought by them. The idea that HBO, for example, has must-have content is actually kind of post hoc. Westworld was not HBO content until it was bought by HBO, and to the extent that it was always going to be must-have content, it could have been must-have content on ABC, on NBC, or on HBO or anywhere else. Now, starting to get into some of the analysis of this, that very fact is actually very important. It's true that must-have content is important in this industry, but it's also true that if AT&T were to, say, restrict access to HBO, now that, assuming it completes this deal, producers who are ultimately in the business of trying to figure out where to sell their shows to maximize their revenue will be less likely to sell to HBO, because by definition HBO will have a smaller market. They'll probably either be able to offer less or less expected ad revenue or subscription revenue down the line. And while it's possible AT&T might somehow reap the reward from this, it's a lot less clear that the specific show will. And so if AT&T were to, for some reason, try to restrict access to HBO, the kind of must-see content we currently see on HBO is a lot less likely to end up on HBO. That makes it a lot less likely that AT&T would actually restrict that access in the first place. Excuse me. And meanwhile, as I mentioned, AT&T is a very large player in broadband access and in cable and satellite markets, but the merger doesn't change the shares of any of these at all. And a crucial aspect of any antitrust case against the deal is that any anti-competitive effects would have to be merger specific. That is, they would have to arise because of the merger itself. And the harm would have to fall on consumers, not competitors. And I think those are a really big problem for the antitrust case against the merger here. First, because deals between Time Warner and AT&T and any number of other content providers and distributors, including exclusive deals, are already possible. And indeed, various combinations of such deals abound. To say that some form of exclusivity is made possible by the merger is not really accurate. Lots of forms of exclusivity are very much possible today. Second, because, as noted, the merger doesn't increase size in any market. Third, because it doesn't change incentives for the merged company to license in or out. Now, this is going to be the most controversial statement I make, and we'll discuss it at length. But for content creators like Time Warner and NBC Universal, teaming up with content disseminators offers a hedge against a tenuous TV business. For a lot of the reasons I've been describing, the evolution of this industry, revenue from traditional TV distribution and even cable distribution is a lot less secure than it once was. The bulk of revenue for content creators, nevertheless, still, I believe, comes from TV ads and subscription fees. But of course, as I said, TV, along with its ad revenue, is in the midst of a seemingly inexorable decline right now. So merging with a broadband provider like AT&T gives content creators a direct distribution pipeline that navigates around the TV and cable distribution platforms and diversifies revenue sources between content and distribution, and also makes new distribution models that we haven't even conceived of yet easier to experiment with. For AT&T, there are all of those benefits, the benefits of new business models, experimentation, diversification, as well as a hedge against high content prices. And I think this idea of a hedge is kind of key to understanding the economics and the antitrust here. Large though it may be, Time Warner represents, as I said, a pretty small fraction of content. Having control over what that content is and its price basically means AT&T won't have to pay, hardly means that AT&T won't still have to pay market prices for the vast majority of its content, but it's a hedge, right? Some small portion of its content it won't have to pay relatively higher prices for, and that can be extremely useful in its business decisions going forward. This is an important reason why it's a mistake to view the risk of foreclosure as significant here. The classic antitrust concern in vertical relationships is that the downstream owner of upstream content or input won't play nice with other downstream competitors. AT&T won't license Time Warner content to Netflix or Comcast, let's say. And there's also a concern on the flip side, AT&T won't distribute content produced by Time Warner competitors like, say, NBC or Disney. But one can easily imagine that AT&T's customers would not be very happy with no access to Disney content. That's especially true if you have kids, but it's also true if you like superhero movies or, say, Star Wars. And of course, after the recently announced potential deal between Disney and Fox, it becomes even more true. And AT&T is paying either $85 billion or something like $105 billion if you include the debt they're taking on, precisely for Time Warner's expected revenue stream, most of which comes from other distributors than AT&T. So cutting off that revenue would be a pretty bad business decision. So, but what about this must-have content? Herald has written, even though I get both people, okay. Herald has written that the competition calculus in cable is different than elsewhere because it's full of this must-have content. One can't compete with DirecTV, say, if one can't show HBO. Or because of differentiation, Westworld isn't the same thing as Stranger Things, and no one can compete offering Stranger Things as a substitute for Westworld. Of course, that can't be the case because currently Netflix does exactly that. And there might be a difference in degree in the amount of sort of must-have content, but it's not a difference in kind. And the entire apparatus of vertical organization economics and our antitrust understanding of it was built substantially on work by people like Oliver Williamson, which began by considering what happens when a downstream supplier, say an aluminum smelter, builds a plant near a bauxite mine owned by someone else. and the owner of the bauxite mine all of a sudden says, oh, hey, by the way, it's double the price for the bauxite now. That's pretty must-have content. I don't see anything really particular to the cable market here that isn't well understood in longstanding antitrust and broader industrial organization economics here. So I have a couple more things to say, which I will undoubtedly have an ability to do after Harold talks, but I'll stop for a moment then. Only a moment, because you're only
Right. Part of the interesting difference here is that I come at this originally as primarily as a communications lawyer. That's where I started with the FCC work. So that's I spent a lot of time dealing with issues of cable ownership, cable concentration, program access in the 1990s, and therefore have a somewhat different approach to this than coming from the antitrust side. But I shall restrain my public interest urges and limit myself purely to a consumer welfare mode and make the counter case. First of all, to frame the article that I wrote, it's important to understand that what I was reacting to was, in fact, the suggestion that there could be no possible case in the entire world against AT&T Time Warner except for the political question of CNN. So part of my argument was, in fact, to provide the historical context to say, no, actually, we have historically within the cable industry had precisely this argument with regard to vertical integration. We've also seen that it worked. It worked in the 1980s and the 1990s. I can point to various other examples in the course of the 1990s and in the development of new technologies where this has worked. And the emerging complexity of this space, as it has come to include broadband distribution platforms, mobile associated equipment, has in fact made it easier rather than harder for players to exercise certain forms of subtle discrimination based on size and the nature of the two-sided platform, where access to the eyeballs gives you influence over the necessary programming, and having the superior programming gives access to the gives you a greater attraction to the eyeballs. In addition to coupling this in combination with things like network effects, which make the automatically jump up your scale the larger your distribution network is. Being a part of that distribution platform is much more important. This is, of course, one of the reasons why there is renewed interest in what had been the uppity upstarts like Amazon and Google, now that they have become giant platforms where denial of access to that specific platform has extraordinary impact on your ability to conduct business. We're now seeing antitrust law at least begin to respond with some inquiry about should we, look at the nature of this. So part of my argument here is that however we wish to describe the set of vertical interests, if we wish to keep the DirecTV as a separate line of business with the terrestrial broadband, with the mobile broadband, with the content creation, and how we view those as interlocking pieces that reinforce each other in terms of the overall power and stickiness of the platform, including in areas of profitability that are critically important that don't fall into what we think of as being the traditional product market in this space. Notably, for example, advertising. AT&T has spent a great deal of time developing a huge industry around advertising, which it promotes as a component in its video content, a component in its cross-mobile platform. So the value and nature of the content is critically important to feeding these various elements of its business, which in turn make it, as a whole, much more must-have and able to exercise market power overall. Now again, this is complex and difficult to prove, which brings me to a second point in these antitrust actions which is frequently overlooked, which is the documents. Jeffrey has pointed out that you have a lot of theoretical reasons why you might think that you wouldn't want to withhold the content, also depending, of course, how you break down the content. For example, when we say HBO is must-have, it's true that Westworld itself could have ended up somewhere else, but when the potential subscriber is making his or her decision about what services they want, they look to things like the reputation of the overall channel. So while it's true they may not yet know that Game of Thrones or Westworld is the thing that they're going to consider to have, must have, want to watch next week, they know that previously HBO produced something called The Sopranos, previously it produced something called Boardwalk Empire, and therefore the value of HBO as a content producer brand is much more significant in terms of the ability of its holder to use that as must-have than you would think from its individual aggregated parts. Again, part of the issue also, just to take some issue with Jeffrey's statement of the case, not to disagree with the overall theory, but antitrust is not based on it could never be overcome. You know, we have a thing called the small significant increase in price, the SNP, which is what we use to measure impacts. Again, on the notion that it's not that I might necessarily be able to charge the full monopoly efficient price to still have market power and be challengeable under the Hart-Scott-Rodino Act, but the fact that I am able to exercise market power as demonstrated by my ability to impose a small yet still significant and non-transient increase in price is regarded as sufficient evidence of market power. It doesn't require me to be able to totally shut out a competitor. It doesn't require me to be able to drive out others into bankruptcy. It simply requires that I have sufficient market power in my bundle to be able to impose conditions or prices that are disadvantageous to rivals, effectively preventing them from lowering the cost to consumers or preventing them from providing challenging and innovative products to consumers. We look then here at the combination, and most specifically the thing that we can't know, which I tend, having been involved in some of these transaction reviews at the Federal Communications Commission, I have learned to value a great deal are the actual company documents and the actual depositions that are provided. I can say that I have been involved, was involved, I can't describe which transactions, but where there was, expert testimony of a theoretical, along the economic lines that Jeffrey was talking about, which purported to show that, it would not be profitable for us to withhold this content. And nevertheless, in the document review, you come across a presentation to the board of directors justifying the acquisition of the property, which has a little spreadsheet which says this is the amount of money we could make by selling this to our rivals. This is the amount of money we calculate that we would gain by not selling it to our rivals, and therefore keeping the customers who might otherwise go to a rival. And this number is significantly bigger than this number. That's not a thing you can know from a theoretical standpoint. That is a thing, however, if you are the Department of Justice, you do know if you have found the right slide deck. The Department of Justice teased out a number of quotes in its complaint that seem to indicate that it has some juicy stuff. You never know in these situations about the particulars, again, because, the stuff that you think is, really juicy might be explained, and a judge might believe, well, that was puffery by people who are interested in selling the merger to the board, and it didn't really mean that they have that kind of, I think one of the quotes was, by withholding HBO, we can totally trash the value of whatever rival they were talking about, You can defend that with no. That was just this particular person who wanted to have the merger close, persuading a board of directors that's not actually really the case, even if that individual thought it was. So these things are not necessarily compelling, but I do say that when I say the Justice Department case is stronger than you think, I do suspect that there is a great deal of evidence in the record that shows that while in economic theory you could go either way, and depending on the nature, I can show, for example, that yes, withholding programming will cost me money. But again, that's not the end of the equation. The other equation is, are there forms of benefit and revenue, such as keeping customers who might otherwise leave, or alternatively, particularly when you talk about multiple platforms, my withholding it from another rival is costing me some money, but the exclusivity that I derive helps me because I also make it available exclusively on my mobile platform, which is huge and is part of a leading demographic coming in, so that, yes, I'm losing the revenue that I might have by conveying this to Sling, but the fact that I am able to find yet another platform and potentially share with another platform that I feel less threatening, makes up for the fact that I'm not selling it to Sling or Comcast or the other direct rival. And also, again, there's stuff on both sides. We see this with retrans, where each side suffers, and this is in the Department of Justice complaint. Each side suffers in a retrans fight when CBS or Viacom withholds its content from Charter or another MVPD, multi-channel video programming distributor, for those who don't look specifically in this area. We find that there is a loss of customers. There is general anger and frustration with customers that may or may not translate into anger at the cable operator or other MVPD rather than the content provider. And as the Justice Department asserts, some people leave every time there's a sustained retrans fight. So first of all, you have incentive to withhold because you can last longer, and you can last longer, and also everybody else knows who can last longer, so the rational actor will want to fold early because they know that it's not a fight they can win. And they also know that they, more than the programmer, will have a loss of goodwill, more difficulty with the customer, all of these other things that they would have to suffer, all of which, show up in the greater advantage which is contained. But with regard to the merger specific, as the Department of Justice pointed out here, AT&T will now suffer even less than would the standalone Time Warner because, first of all, it will have its own outlets which the disgruntled viewer can turn to, and thus hope to pick up some of these subscribers who will leave the rival, and also because it has alternative outlets through which it can make this make up the loss of revenue from the programming. It will simply suffer less. So these were all elements that were present in the complaint. These are all elements that I think are significant and important. Finally, as I said, we go back to this. Oh, yes, sorry. No, I understand. To try to wrap this up quickly, as I've just been advised to, complicated mergers and issues, these things, you have, an area of tremendous dynamism. The question is how you read that. The Department of Justice has had a great deal of experience in this particular industry over the last several years. And part of the question of where does the consumer welfare lie in this and what are the incentives are, how do you manage a transition if you are the incumbent? And one of the harms that was identified, in the Charter Time Warner Cable, which was, again, horizontal rather than vertical, but where we started to see concern about this, is this ability to, through contracting clauses with rivals, with program suppliers, prevent potential competitors from being able to compete on price or being able to compete by offering different packages and different modes of viewing because of contractual provisions that I can put in because of the size of my platform. The Department of Justice case rests in part on this idea that by combining a video provider, which already has significant power to dictate the nature and the evolution of the market, with an MVPD content provider, which has, in addition, multiple new outlets and an installed customer base of over 100 million on its mobile platform, that each one of these already possesses significant ability to dictate the transition in the marketplace, and that by combining them, the combined power of the two enhances the market power to dictate this transition that we are seeing over time. Let me end there. There are always more things that could be said, but let me now bounce back.
Very good. Thank you very much, both of you. I want to get to audience questions as quickly as possible, but there's a lot on the table, so I want to go back through and give each of you 2 or 3 minutes to respond to each other, if we could. So Jeff, take a couple minutes.
That's just saying, okay, let me identify a couple of things I would prioritize here. One of the things that I think Harold was suggesting was that that the size of AT&T's distribution network makes it a sort of must-have platform. If you're going to be a content provider and be successful, you essentially have to be on AT&T's network. I don't think that's true as a descriptive matter. But I also think that it brings to mind the reality that on both sides of this market, on the content side and the distribution side, anything AT&T might do to either impede the distribution of content or impede other distributors from access to its own content would anger some pretty massive players. It's not like AT&T would have free rein to be able to make this sort of decision without any ramifications. So if, for example, it withheld HBO from Comcast, I hardly think that Comcast would just say, okay, that's fine, we'll just go with that. I also think that one of the first things that Comcast would do is make sure that it's providing a sufficient outlet for content to make itself relatively even more attractive, so that it becomes the must-have platform, even if AT&T is trying to sort of corner that market. And of course, obviously, and on the content side, it's even more apparent. If AT&T were to say we're going to stop distributing Disney content, as I said before, not only would I think that it would lose an enormous number of customers sort of instantly, but I also don't think Disney would take that sort of lying down, and I think that there are any number of so many complicated interactions among all of these companies that it would put at risk so many sources of revenue that in various ways depend on Disney or the cooperation of Disney, or Disney, for example, not entering into other difficult agreements for AT&T with its competitors. It's just, I mean, you're right to say that we don't know with absolute certainty, but the complexity here makes it so that we really don't know with absolute certainty, and the fact that we don't know the fact that we don't know is probably the best argument against blocking the merger, because blocking the merger is what you do, or prohibiting conduct ex ante is what you do when you're certain that it's going to cause harm. But when you're unsure what the consequence is going to be, you don't prohibit the conduct. You allow, for example, the merger to happen, and when and if these pernicious results arise, the DOJ, FTC, and many other entities are, of course, there to ensure that those specific actions, if they actually have any competitive consequences, are dealt with. So I just don't think that the fact that you can identify AT&T as a large player, for example, or any of the other things you mentioned, is a sufficient basis to thwart the merger.
Let me stop you there, and let me interject here really quickly. If you want to ask a question, make your way to one of the microphones. And Jeff has sort of posed the first question I was going to ask of both of you. I was
hoping I could get 2 minutes.
Yeah, you will, and
okay.
I just want to put this on the table, and that is that I thought I heard you, Harold Feld, say that this is a close call. So I wanted to give you a chance to respond to what Jeff said. In the case of a close call, if it is, why don't you defer?
Right, and let me, Jeff's response and raises one of the points that I had wanted to make and had not, which is one of the fascinating things in the complaint is that the Department of Justice raises the coordinated effects issue. Jeff is exactly right that the reaction that we tend to see in the market when you have this consolidation is more consolidation, both vertical and horizontal, because it's an arm race. Everybody bulks up. That it is important to remember that the standard under the Hart-Scott-Rodino Act is a likelihood of substantial harm to competition, loss of competition, harm to competition. But the point is, it's a substantial likelihood. Again, not metaphysical certainty. And not even a sort of, if we were prosecuting a criminal case, beyond a reasonable doubt. Somewhat more possibly than a preponderance of the evidence, but the fact is that we acknowledge, and part of the whole purpose of the Hart-Scott-Rodino Act, as opposed to an action under Section 1 or Section 2, is that we try to take into account predictions about the market as a whole and likely consequences going forward, post-merger, not just of the individual actor, but of the market as a whole with regard to the overall risks of competition and consumer welfare. I think that what tips the scales in a close call like this is not merely both the history of the industry, which at multiple inflection points we've seen that the power of the large platform, the power of the two-sided market of control of the customers on one side being leveraged against the program providers, and then back and forth to create a synergistic form of market power. We can look at that history, but in addition, we do have to look at the question of the responses that are being engendered in the market and ask, okay, at what point do we draw the line? And I think that in a case where, okay, it's a close call, when you then say the additional harm from potential coordinated effects, again, part of what goes into this calculus of how much do I know or how much I don't know is the more I know what you're like because I'm like that too, the better my ability as a rational actor to guess and coordinate without explicit coordination. So that's where I think we should tilt the scale, and where I think DOJ is tilting the scale is with regards to this concern that we're reaching a level of concentration that facilitates significant coordinated effects among the very few large-scale players.
Can I just make one quick response? So one of the things that you have to bear in mind here in the antitrust context is that you have to identify actual anti-competitive harm. And I think in this market that would have to be something like higher prices to consumers or a demonstration of a restriction in the amount of content being produced seem like the most likely sort of candidates there. The problem with the kind of dynamic that you were describing, short of cartelization, is that you might see a redistribution of content. You might even see a redistribution of subscribers between various options, not of course just competing cable channels, but all of these other distribution channels that I've described before. But none of them strike me as being likely to lead to either a reduction in the amount of content or increase in price. And I think that you or the DOJ would have an extremely hard time demonstrating that, leaving aside the fact that I think the incentives for AT&T to engage in that conduct in the first place are extraordinarily weak. I think one of the reasons is because I don't think it would lead to a greater ability to charge higher prices, nor do I think it would harm consumers by restricting the amount of content, because there are so many alternative distribution channels, because of the way content is actually created and distributed. The collusion point is one where I have to say I get the idea that if there are fewer players in a market, perhaps it's arguably easier for them to collude. But
well, it's not collusion; it's a coordinated effects, and it's important to make that distinction. Collusion requires my actual communication with me. My coordinated effects is much more if nobody plays bridge anymore, so I can never use this analogy, but it's more of a, if you imagine the classic movie where the gunfighters are going, yeah, I know you could draw, and I could draw, and I know you could draw, so why don't we both put our hands down? Because we both understand what we're doing. We are similar enough that we know what the rational outcome should be for any one of us individually, which therefore allows us, without collusion, to determine what the outcome is.
But the whole point here is that a merger like this actually makes the AT&T and its competitors much less similar rather than more similar. I think part of, you of course have made the assertion about must-have content. That implies that owning one piece of must-have content, if you're AT&T, doesn't actually tell you all that much about what happens if you own a completely different piece of must-have content. If you're, say, another vertically integrated distributor, it might tell you something, but I certainly think that certainly the stated intentions and the most obvious, sort of the Occam's razor explanation for engaging in a merger like this is that you're being confronted with a really rapidly changing and sort of disintegrating kind of traditional industry, and I'm certain that AT&T thinks that by engaging in a merger like this, it will be able to differentiate itself from its competitors, come up with new offerings that don't look anything like what it has offered before, and there are other problems with what you said, but I think the coordination point, if you're basing that on the fact that you are very similar to your competitors, is actually unlikely to be the case here.
I don't want to stop us if we have questions, but
the floor is open to questions. If you have a question, to the microphone, please.
Mr. Feld, I remember that in the 70s, well, late 70s and 80s, the Federal Trade Commission did the conscious pricing or price matching without collusion in the cereals cases, and that was a terrible disaster. They spent millions of dollars trying to prove it, got nowhere, and it came out that, well, they may, in fact, know what other people's prices are on the mantle, but they're not going to match it for that reason. There's a lot of other management decisions. So I'm not sure if that works with such a hydra of factors that you have here.
This is a fair point. Again, this is where the question of what do the internal documents show, and also what does historical practice show. What we saw in the cable industry when it was the MVPD industry is that, in fact, people try to bulk up so that they will have chips to trade with each other, because they understand that if there are many different pieces of the must-have programming. So the question is, what do you got in your hand that you can use to trade with somebody else? Because if you don't, then you have, you pay more, you're subject to, greater pressure from one provider or another. It's why we have consistently seen greater and greater consolidation, and also where the consumer harm of more prices comes in. I would argue, and in fact I have argued, that the problem that we have had in traditional cable TV programming for a number of years has basically been that it's not, we have essentially two dueling, highly concentrated, I won't say cartels because there's no enforcement mechanism, but you have the increasingly concentrated distribution mechanism, with distribution platform that justifies its enhanced size as a means of being able to exercise negotiating power as against the programmers. And if you look at Sinclair Tribune, that's exactly what they say that they want to do. They want to be big enough so that they're able to negotiate effective retrans against Charter and Comcast and DirecTV, whereas if you look at the smaller MVPDs that are opposing it, they're concerned that because those guys are now larger content providing platforms through retrans, that they will be able to exact much higher prices for consumers as a consequence of this, because they're stuck paying to get the must-have local programming. So
That sounds like a great reason for the merger.
Well, for whom? That's the question. The answer is, as we saw, consumers, however, end up paying more because each side jacks up its price to the other. It did not result It has not resulted, as we have seen in the MVPD industry traditionally, it has not resulted in cheaper prices. In fact, bluntly, one of the reasons, in my personal opinion, why we have started to see a rise in cord cutting is because a long time ago we passed the exit for the monopoly efficient price and actually started to hit the point where no matter how much you want the programming, it's just too expensive. And that's not because cable guys are colluding to raise the price above the monopoly efficient price, or that programming guys are. It's just that this seesaw in which each one asks for more after they bulk up and then they equalize has resulted in a constant spiral of price increases that has just been impossible to sustain and from which consumers have suffered.
I both think that I view the history very differently than you do, and also the consequences. I think with respect to the retrans issue, of course, once all content is being delivered through unbundled digital distribution, retrans won't matter anyway. But that's actually instructive because we do have a lot of content that's being distributed through digital MVPDs or OTT or OVD providers, which are not subject to those rules. We see lots of exclusive agreements being entered into between content providers and distributors. And what we have seen in conjunction with that is hardly spiraling prices. If anything, I'm pretty sure that prices have been coming down, and a massive increase in both the amount of content and the multiple channels and methods by which you can view it. I mean, I think it's very hard to look at the sort of relatively recent history in these markets and say everything's going to pot. Not only have prices not gone up in any of these in any of the area for subscribers, not only have prices not gone up, but the amount and quality of content and the quality of the mechanisms for distributing it, the video compression technologies. I mean, sort of essentially every aspect of video creation, distribution, and viewing has improved immensely, while prices have not increased, and the amount of content has gone up.
I actually disagree with you as a function of actual, again, trying to figure this out, particularly, since the FCC is now talking about no longer collecting the cable cost data, but at least over the last several years, for which we have publicly available data, the price of MVPD subscriptions has risen faster than the rate of inflation by a considerable degree. The price that ESPN and other must-have providers has likewise increased. This has been a matter of considerable contention, with especially a complaint among the smaller players. I would add that particularly when we factor in other fees that are part of the cable price, which are increased on an annual basis. My favorite, of course, being the set-top box fee, rental fee that keeps getting increased even though I don't change the set-top box. But nevertheless, I'm paying an additional $1 or $2 every year, every month, every year for the same set-top box that I got when they installed it. That these are forms of price increase, and that in fact, the price of traditional cable and video programming as delivered through traditional MVPDs has in fact increased over the last several years.
It hasn't. It simply hasn't.
Yeah.
If you measure it on any sort of sensible basis, whether it's hours of viewing, number of channels, number of hours of content produced, and this is not even quality adjusted, but on any of those bases, the price has gone down. Inflation adjusted price has gone down. And if you actually engage in any kind of a quality adjustment, the price has gone down substantially.
See, this is where I always have this argument, and this is where my consumer advocacy hat a bit, is as I like to say, the problem with these sorts of calculations is that they're not actually how consumers view it. Every month I write a check. If the number on that check keeps going up, then I view it as a price increase. It does not matter if I am now getting additional channels, if I have no opportunity to say, no, I prefer the cheaper bundle. So a measurement on a cost per channel.
Of course, you do have that opportunity increasingly, and a merger like this will facilitate that, not
I would say that we have had that we are indeed finally starting to see some experimentation with skinny bundles. I applaud that. I applaud the arrangements that are being made, but they are in fact being made outside of these merger contexts, such as Verizon and its negotiation for skinny bundle purposes, such as EchoStar, well, what do they call it? The Dish Sling for skinny bundles. I will add that these have been, fiercely resisted by a number of the incumbents, and I certainly applaud those MVPDs that are experimenting with it, but they are simply not, from a consumer perspective, broadly and widely available. The cost has, as measured by what people pay, has been going up.
Let's interrupt this for a moment and take another question from the floor. Somebody's been waiting patiently. Go ahead.
Thank you very much, and thank you for your presentations. As I understand it, AT&T and Time Warner have offered to address many of the concerns that the DOJ raised in its complaint in such a way that arguably some of the concerns in the complaint are eviscerated. To wit, again, as I understand their, in effect, settlement offer or proffer, they have said that they will not black out content, and they have offered to submit any issues regarding price increases for content to a system of arbitration that's been likened to the arbitration system that governed baseball. Now, relatedly, the judge in this case oversaw, I think, the NBC-Comcast merger. He had some issues, I believe, with some of the offers, not unrelated perhaps to those I just mentioned on AT&T Time Warner's part, that were made on behalf of NBC Universal. Does anyone who knows his supervision of that case know how he might be likely to come out in this case? And finally, also relatedly, and bearing on the point that, or the argument that Professor Epstein made so well in another Federalist Society gathering such as this, what are the chances that this contretemps can be resolved before trial, given this proffer offer, in effect, settlement offer on AT&T Time Warner's part, in light of what this same judge did in the NBC Comcast case? Thank you.
All right, I mean, this is a good question, and it's frankly one I get a lot. I find this very fascinating because, for me, what Del Rahim is saying, and what has actually been the traditional conservative antitrust hawk tradition, has been behavioral remedies are a terrible idea. They transform antitrust from law enforcement to regulating the market. And what ATD has essentially put on the table is a behavioral condition. True, they have tried to emphasize that because of the Federal Arbitration Act, it would somehow not be regulatory, but the reality is, particularly if it is then going to be overseen by a court to ensure that AT&T really does, follow, somebody has to make sure that AT&T is following its agreement. So in the end, it basically becomes a form of regulatory behavioral condition. The Obama administration was all into that. I mean, part of it is when we say we're comparing it to Comcast NBCU, what was at the time a marked shift in the early part of the Obama administration to behavioral remedies, which I think in part came from the fact that they'd lost the Oracle PeopleSoft case and it made the DOJ a little gun-shy. But the rationale was that a more flexible approach would allow them to capture the efficiencies of mergers while mitigating the harms. There has been significant pushback on that from both the right and the left. I suspect that, in fact, if we were in a Democratic administration, it would have been a behavioral remedy. But I don't think Delrahim is wrong to insist on saying we don't do behavioral remedies here. We are going to do structural remedies. And therefore, and I expect actually in the context of this, for the Department of Justice to argue the court does not impose a remedy. You don't, this is an enforcement question. We either prove our case or we don't prove our case at this stage, and it is not, for the court to allow defendants to engage with a negotiation in the court on what would be an appropriate settlement offer. I actually think, given the nature and character of who's running the Department of Justice, that this is not going to settle. Both before and after becoming Assistant Secretary, Magen Delrahim has made it very clear that he does not like behavioral remedies. And additionally, I think that given the history and nature of this judge, I was a participant in the Comcast-NBCU merger review, and Judge Leon's objections at the time were that if things are as bad as you say they are in the complaint, why aren't you just challenging this? Why are you having a condition? And the DOJ made arguments and said, well, the FCC has signed off, they're the expert agency, we'll have greater accountability requirements. So Judge Leon was like, yeah, okay, fine, I'll sign off on it, especially since you rarely get a judge that won't sign off on it under the Tunney Act. To the extent the history suggests anything to me, it suggests that the court is not going to try to push the parties to settlement. And if anything, I expect the DOJ to be able to frame their case as, gosh, Judge Leon, you were so right back in 2010, in 2011, we were so wrong, and now we, a chastised DOJ, stand before you, ready to do what you wanted us to do the first time and go with a structural remedy rather than a behavioral remedy.
So here's what I think is really most crucial to think about with respect to behavioral remedies. They come in essentially two types. There are behavioral remedies that are aimed at addressing the potentially anti-competitive conduct that might arise as a consequence of the merger, the kind of thing that we've been talking about, foreclosure, for example. So you saw those in the NBC Comcast merger, things like agreements not to withhold content from competitors. Those, while I don't necessarily think they were even necessary there, they at least actually address the theory of anti-competitive harm from that merger or potentially this one. There's another type of behavioral remedy, and that type is the type that actually has nothing to do with addressing any competitive consequences of the merger, but is an opportunity to extract something from these companies. The FCC is absolutely the master of this, but the DOJ has done its share of it as well.
It's their job.
And those are the kind of remedies that that I think everyone agrees, and I think that's largely what Macon is thinking of when he is criticizing the behavioral remedies and the way the DOJ has used them in the past, and it's certainly how those of us on the alleged right would criticize the use of behavioral remedies in the past. It's those extra legal ones that are the problem. The reason the other ones are actually not a problem is because they're no different. There is no increased monitoring obligation or any other kind of obligation placed on the Department of Justice to enforce a condition that is actually tailored to address potentially anti-competitive conduct. In other words, something that if it occurred would be deemed anti-competitive, that's the DOJ's job, whether there is a merger agreement in place or not. It is actually engaged in monitoring not only the companies we're talking about, but every other company to make sure that they don't engage in that kind of conduct. So if you actually have the right kind of merger remedies, there's actually not very much difference between the DOJ's obligation under the law and under the particular merger remedy. If anything, it's simply easier to deal with the problem because if the parties actually violate the terms of the consent order, the DOJ has a lot more powerful tools than if it actually has to bring them to court and make out a new case arguing that its withholding of content, for example, was anti-competitive. That doesn't mean that I approve of the merger remedies, but it does mean that it's important to bear in mind that one might protest too much about the adoption of merger remedies, again, if they're actually tailored to the anti-competitive harms. The other thing that has to be mentioned here in this context is we already have a regulatory regime enforced by the FCC that deals with a significant amount of exactly this sort of conduct. We have the program access rules and program carriage rules.
We
that,
don't.
That, what do you mean we don't? We
They expired.
absolutely do. No, they didn't expire.
Yes,
The
they did.
presumption, the prohibition on exclusivity expired, but the rules are very much still in place.
We have a very different interpretation of what happened.
Well, the rules are still there. The only thing that expired was the prohibition on own content exclusivity, and they absolutely still exist, and excuse me, and are enforceable by the FCC. And that doesn't mean that, I mean, one could argue that that's an insufficient regime to make sure that these kinds of terrible things might happen, but it is in fact a regime that is already in place, whose job it is to monitor exactly this sort of conduct, at least with respect to other cable providers. I don't know that it would actually, in fact I know that it wouldn't have bearing if you were to withhold content, say, from a Netflix. And so it's not complete, but it's absolutely pretty important to consider here. So,
I will say, because I am very interested in understanding when you say that the program access rules still exist, if what you mean is simply an enforcement action pursuant to Section 628B without any other implementing rules, or is that what you mean when you say they still exist? Just a straight 628B?
I mean, a competitor can complain that the withholding of content was unfair and prevented them from being able to sufficiently compete. It would be adjudicated by the ALJ under exactly the same terms as it always has, except again without the prohibition on.
I don't. All right. I don't want
vertical exclusive dealing.
I don't want to get into that. It's. But yes, it's. Two lawyers, three opinions. Okay, let's.
Another question.
Yes, I see that there's a lot of emphasis in the complaint on DirecTV being a major part of the anti-competitive danger. What would your thought be if they divested DirecTV? Would that kill the case?
Well, it would kill the deal.
It would absolutely
If I
kill
were
the case.
AT&T,
That's
I
in
would-
fact.
I would
That was
absolutely
in
would.
fact what we heard DOJ ask for in the negotiation. They said, look, you know, divest DirecTV or divest the Turner suite of programming, which includes CNN, HBO, TNT, you know, a wide variety of other programming. And what the DOJ said as a behavioral remedy was you divest one of these two and the problem goes away. And AT&T said, no, we don't think we should have to do that. We're willing to.
No, they said we're not going to.
Right,
we don't want to do the deal.
We don't think we're not
without
going to do
those.
that. Right, they said that's not what we're going to do. So they are confident. You know, AT&T is and Direct and Time Warner are confident in their case that they can prove it in court, and you know that's why we have judges.
Well, I mean, they are confident they can prove their case, but again, the relevant comparison is to the but-for world. They would rather take their chances in court, even with some risk of losing, than simply say, okay, well, we'll do the deal, but we'll give up DirecTV or Turner or you know, whatever it
Right.
was.
I suppose
So-
my simple overall point is that the Department of Justice is very consistent with regard to the theory that it is presented and the nature of the structural remedy that they have asked for under that theory. Whether you think it's the right one, we can argue, but at least they're consistent.
Well, I would just point out, I suppose you could say it's consistent. I would just point out that that kind of a structural remedy, though, does either ignore or significantly diminish the arguable efficiencies from engaging in the merger in the first place. It basically says, well, we don't care about those efficiencies that might arise from being a larger distributor or a more powerful negotiator, whatever it is you think they come from, because we're going to just split you up or we would like to see you split up into multiple pieces. So maybe that's consistent, but it's actually not really consistent with the law, of course, which does indeed require them to take account of exactly those sorts of efficiencies.
Well, it's weighing the efficiencies against the potential harms. So, you know,
Right, and maybe they did that.
they're right. I was going to say, you know, the
fair.
problem is we can each say what the formula is. Assigning a value to each variable is where the fun happens.
Right.
Another question? All our questions seem to be coming from the right. I'll observe.
Yeah, well, I am reminded of a merger that was attempted earlier this year or last year, which is Office Depot Staples. And the argument behind that is that Amazon is coming. They're small now, but they have a cost advantage based on their overall scale. And when that was turned down challenged by the FTC, the participants took the unusual step of going to court. They lost. There was deference to the judge. But I think Wall Street is generally of the view that merger will occur in the future with weakened companies as Amazon grows. In other words, the FTC did not have their eye on the ball correctly as to where the puck was going. Now, this morning in this field, we have Fox Disney being announced, and from the reporting on CNBC, Disney, that is all about competing with Netflix and Amazon, who are going 100 miles an hour in the space, you know, disaggregating, you might say, the whole model of cable TV. I know, Mr. Mann, you had pointed to this earlier. So I'd like you to go back to that and discuss this a little more about the context of where the industry is going and the overall challenge to it as being, you know, supporting not just this transaction, but a bunch of other transactions that are going to be coming in a bunch of other fields.
Sure. I mean, if they're doing their job, and often they do, the attorneys and economists at the DOJ and the FTC think about things like that. But they also are very circumscribed, and they're very careful, maybe the right word, but you could use a more pejorative word, about excuse me, about that kind of prospective efficiency, about the argument that competition is shifting in such a way that we need to do this merger now or undertake this conduct now in order to compete in the future. I think that's a horrible mistake, because I think that's precisely why this merger is happening. It's why the Disney-Fox merger is happening. There are a lot of reasons why, but the changing nature of content creation, distribution, and viewing in this industry are really important here, and they're happening pretty fast, and it's really hard to keep up. So the fact, for example, that I don't even know if it's true that Amazon maybe accounts for a relatively small fraction of viewership of specific types of content out there is no reason to assume that they won't be a massive part of that market in the very near future, and that if you wait until they are, to allow companies like AT&T and Comcast and others to try to pivot to compete with them, that by then it will be too late. But that said, I hardly think that Amazon and Netflix are really even the sort of primary drivers of a merger like this one, or at least I would say, even if they didn't exist, I think you would still be seeing mergers like this. I think that people used to say content is king, and if you do some searches now, you'll find Harold maybe even said this. You'll see other people saying content's not king, distribution is king. And it goes back and forth. It goes back and forth all the time. And the reality is that the one you don't have is king. And that can work in lots of situations for various periods of time. But the reason we're seeing now, and it's only very recent, it is certainly not the history of this industry, increasing vertical integration here is precisely because enough changes have happened, not just competitive, but also technological, and also in terms of how the business is working and how the viewers are viewing content and various other things that make it so companies are recognizing that if they have one and not the other, that they're in a severely weakened position, that they're paying higher prices than their competitors, that they're able to offer far less interesting, innovative products. And again, Amazon and Netflix are a part of that story, but they're by no means, I think, even the most significant drivers here. I'd say you could have this exact same merger just on the basis of very traditional companies on both the content and distribution side competing with each other. You'd still be seeing this.
Well, let me answer this question by saying that, first of all, it is a real interesting problem to assume that the future would have unfolded in exactly an identical path that it did, that Amazon would have enjoyed exactly the same level of success, that nothing would have changed except somehow it would be better. In fact, let me suggest that FTC had it right at the time. Now Amazon is a larger percentage of the market. That was to the benefit of consumers because Amazon got lots of low prices and innovated in the business model and did all that, good consumer welfare stuff. Now it's better for these two to merge so that they can form more effective competition. So, and this is again one of the questions we get in the form of, emerging industries. Do you believe that when incumbents come and say, these competitors are small now, but we want to be able to compete better against them, that is a consumer welfare benefit or not? And if you run the calculation and say, well, yeah, you'll compete better because you'll have market power and you'll be able to impose higher prices on your rival, then that's a bad thing, and under antitrust law, we don't get it. I will say certainly one of the issues that we have been seeing and that has caused interest in antitrust with regard to the Silicon Valley platforms, particularly Amazon and a number of others, is it is always the case that yesterday's scrappy upstart new entrants are today's incumbents. That's part of how the market works. That's supposed to be the good thing about the market. Part of the role of antitrust is to let us choose as consumers which ones, whether today's incumbent should be tomorrow's incumbent because, they're actually offering better service, or whether the new challenger is going to succeed because they're actually offering me more of what I want. So I don't think you can properly say that it's a
restraint.
Or
let the market play out as it will.
Well, again, this is the the classic problem of, and this is again, we all agree on what it should be. It's just a question of what values do you assign to the variables. Is the question of does restraint mean that we need to protect a existing dynamic market by preventing further consolidation? Or does restraint mean we just don't make a decision because we really should just be doing enforcement rather than merger review?
So let me ask something that might tie some things together. It might just confuse things. I'm not sure. For Harold Feld, if in such a dynamic market, why isn't the default sort of let the market work?
Well, I would argue the default is let the market work. I mean, we have had a large number of deals. I don't think, for example, anybody is going to say anything about T-Mobile's acquisition of Layer 3 because, this is not, this may potentially change the market, but it does not impact the existing current market. We have seen other deals and other forms of consolidation over the years that have not raised much of an issue. This is the extraordinary case. This is a huge, now again, you might say, well, but I don't think it's that extraordinary. But the Department of Justice has argued, and I agree, that no, this is exactly, this is where that variable hits that mark.
Yeah.
As opposed to Discovery buying Scripps Howard. Nobody cares.
So I wanted to give you the chance in your response to respond to Jeff's comment about post hoc remedies. Why are those inadequate in a case like this?
And for this, look, there is a reason we did that Congress passed the Hart-Scott-Rodino Act. And that was a recognition that Post hoc remedies have two problems. One is they're effectively harder because you do not have nearly the same level of access both to the companies and to testimony from their rivals when you begin an investigation. It can be disruptive to companies in their function when you begin an investigation. If DOJ announced tomorrow that they were, Senator Blumenthal has asked them to investigate Comcast NBCU. If they said, yeah, turns out merger remedies were, without the merger remedies, the problem still exists. We're now going to do an enforcement action. That would clearly have impact on Comcast and their business operation, their stock. So to some degree, we are doing everybody a favor by trying to get this done earlier, and we're frankly doing consumers a favor because one of the problems is with post hoc enforcement is you have the cost to the consumers from the behavior for as long as it takes for that behavior to be discovered, to be proven in court, and to be appealed. So the argument is, the counter argument is, but we're missing all these efficiencies by not allowing the thing to progress until we have evidence of actual harm. So, as always with a lot of questions in policy, I'd say, okay, which do you fear more? There's no, to my mind, that is a policy argument, which we can argue. There's no, unlike, say, the law of gravity, which will tell me exactly how fast this will fall when I let go of it, there is no similar certainty with regard to what is the right answer on when is the pre-merger challenge better because the risk of harm is substantially greater versus the potential loss of efficiencies by not allowing the merger to proceed and engage in post hoc action.
Let's try and get this final question on the table.
Yeah. First of all, thanks for the lunch. Very, very informative. I've enjoyed it. I just wanted to make one statement. First of all, I think some of the discussion kind of shows how irrational antitrust law really is. I think you're trying to guess what's going to happen when it's not possible. Let us figure that out as individuals. The other question I have, or the statement I have, and I'd like to get a reaction is, my understanding of AT&T's motivation for this merger is to compete not with Netflix and people like that, but Google and Facebook, and become kind of a clearinghouse for advertising information. That hasn't come up at all, and if that is truly their motivation, it seems to support the idea that they don't want to limit distribution or harm consumers and things like that. Comments along those lines?
I'd say it's even less of a motivation than the competition with the Amazon and Netflix. I think that I will say that there is a lot to be gained from the combination of distribution networks and content providers precisely because of the kind of data they have, both in terms of the ability to improve your advertising return, but also in terms of how you decide what content you're going to make and how you distribute it. And there's a lot of information that AT&T has that Time Warner doesn't, and presumably vice versa. So combining all of that together, I think, makes them both more effective competitors. I'd be surprised if a really significant part of this was, and they're going to make us enough more competitive, enough stronger competitors that we're going to start moving into, sort of dominating the advertising market against the Googles and Facebooks of the world.
That's a statement I've heard.
Well, no,
That's the business model change that AT&T is driving towards.
Well,
I think the most likely business. I mean, I don't know. I haven't read that, and it's possible that someone has said that, and I'm a lot more skeptical of what business people say. They know a lot less about their business than they think they do. But I think, not that I know a lot. Don't get me wrong. But I think it's possible. I mean, I think the big motivating factor behind this is I really do think innovation, new business models, new opportunities that either don't exist or that other entities are able to do and that AT&T sees as, you know, sort of the future, but mostly things that they haven't tried, that no one else has tried, that are facilitated by owning both the content and distribution. And it could be that some of those are aimed at, you know, competing with the Googles of the world. That's just a lot farther from their core competency than you know, are aiming at the Netflixes of the world, or again, aiming at some other model that doesn't even exist today, but is nevertheless rooted in the creation and distribution of video content. So it's possible. You know, it would be a pretty hard sell to investors to say we're going to move into a market that we've never really done a whole lot in, but this is going to enable us to do so. Not irrelevant, but I wouldn't think it's the primary thing.
A couple of things. One is AT&T, along with Comcast and a number of other providers, have indeed been making huge moves into the advertising market. There's still a relatively small percentage. I don't think you have to be imagining that you're going to be, I mean, part of this is, there are a couple of things here where I'm like, okay, do we believe in rational actor theory or not? When we talk about things like the intent of the company or the motives of the company or whatever, I'm like, yeah, okay, but if I believe in rational actor theory, then in theory, you know, that at least the way we think this works is I line up all of my numbers on my variables and I say, okay, you know, what do I think a rational actor would do here? Do they have, and it's not limited to, I mean, part of the problem is we're sitting here thinking like there's one thing that, you know, Randall Stevenson must have been thinking when he approached with this offer. I'm like, I don't know, they're a big multinational company with lots of different units. I'm sure that they believe that this will be an enormous boost to their advertising line of revenue, which is at this point, you know, you see projected ad growths. I've seen projected ad growths of, you know, their behavioral cross-platform advertising revenue growing to several $billion a year. I would bet that would still be a relatively small percentage compared to Facebook and Google, so they're not going to steal the market away from them. But you know, a couple of billion here, a couple of billion there, it starts to add up into a company. But the question then again is when you're saying, okay, does the fact that they're looking to enhance their ad revenue mean that if they had the opportunity to crush Sling as a competing mobile platform, that they wouldn't do it because it's just not worth it today? No, if we believe in rational actor theory and we plug in the variables and you say, yeah, it would be totally worth it for them to go after Sling, Go90, and a couple of these other emerging platforms that are directly competitive to their mobile DirecTV, as well as their disaggregated bundles like the HBO Now, and that would make sense for them to do, then I have to assume that given both, you know, the incentive and the capability, you know, they'll do it. The question then is, you know, Jeffrey will tell you that they don't have the incentive to do it, and even if they were dumb enough to try, they couldn't actually do it, so don't worry about it. If they try it, they'll just, you know, fail. But I think we both, you know, but I think both of us would agree, or at least I hope both of us would agree, that, you know, we need to conceptualize this as a almost mathematical exercise rather than as something, you know, trying to put ourselves in the shoes of a CEO to think what his or her big idea was in the transaction, because there's going to be a lot of it.
Well, thank you all for coming. I'm going to join me in thanking the panelists.
Thank you.
Thanks, everyone.